Thank you, my Lord Chief Justice. What is the effect of the Election Laws Amendment Act 2017 on the conduct of the presidential election held on the 26th of October 2017? And two, is Section 83 of the Elections Act as amended unconstitutional? The second and third petitioners plead in paragraph 74 and 75 of their petition inter alia that the Election Laws Amendment Bill 2017 was intended to diminish the role of technology in elections, open election results to manipulation, and signal to voters that it would not be possible to successfully challenge the results of the fresh presidential election, even if the same were to be unconstitutional, unlawful, or irregular. They state that the said bill has since become law with the overt approval of the third respondent and has been gazetted as Election Laws Amendment Act number 34 of 2017. Consequent upon that pleading, the petitioners raise for determination by this court at paragraph 140 of their petition the issue that in light of the amendment of Section 83 of the Election Act by the Election Laws Amendment Act 2017, after the conduct of the fresh election, the question would be, which law is applicable for purposes of determining the present dispute, and two, whether Section 83 of the Elections Act as amended is unconstitutional and invalid. The petitioners then seek various reliefs, the one relevant to the above pleading being that a declaration be made that Section 83 of the Elections Act as amended is unconstitutional and invalid to the extent of its inconsistency with the Constitution. As regards the issue of the applicable law in respect of the 26th of October 2017 election, our view is that as at the time the cause of action arose, to wit, the 26th of October 2017, the law then applying was the Elections Act 2011. The amendment laws did not become effective until the 2nd November 2017. In that context, therefore, the common practice is that legislation should be effected prospectively and not retrospectively. That is to say, laws should be forward-looking and should not apply backwards in time. Prospective application of legislation is based on ancient Roman and English law, and we've given you a quotation there. We've also quoted some American case where the court said, as I quote, the principle that the legal effect of conduct should ordinarily be assessed under the law that existed when the conduct took place has timeless and universal human appeal. It is a conventional rule of construction that legislation must be addressed to the future, and a statute should not be given retrospective operation interfering with antecedent rights. We are inclined to the standpoint that legislation should bear only prospective effect in the absence of special legislation signal to the contrary. Where a legislative body thus wishes to change the law regarding a past event or action, its intent is to be clear enough. By this principle, where legislation is ambiguous or silent as to its effective date, it should be presumed to be prospective. In the present instance, when Parliament passed the amendment to Section 83, it did not state that the law shall apply retroactively. The United States Supreme Court in Landgraf made this presumption to statutes altering substantive rights. That court presumed prospectivity to avoid construing a new law that otherwise might have attached new legal consequences to events already completed before the law enacted. Although the Landcraft case dealt with private actions, the reasoning is, in our view, germane to the instant matter. This court has furthermore already pronounced itself on the retrospectivity of laws in the case of Samuel Kamau Macharia and KCB at paragraph 61, which we have reproduced. The issue in this petition, however, is that the amended law was not made retroactive by Parliament and should therefore be read prospectively. It is noteworthy that in addressing the same issue in Moses, Masika, Wetangula, and Muskari Kombo, the Court of Appeal adopted the dicta in Morgan and Simpson and took the position that an election must be guided by the law as it was on the date of the election. And we have reproduced what the Court of Appeal said. From the foregoing, we find that the applicable election law in respect of the conduct of the 26th of October 2017 election was the Elections Act 2011. The Election Laws Amendment Act 2017, Act 34 of 2017, not having come into effect as at the time of that election, and the same not having had retrospective application. The second issue is this. The second and third petitioners seek a declaration that Section 83 of the amended law is unconstitutional and invalid. Having taken into account all the submissions on the matter and being aware as we are that the amended law is the subject of various pending causes before the High Court, such as in the petition number 548 of 2017, the Katiba Institute Africa Center for Open Governance and the Attorney General. We restate our stand in similar circumstances as we did in the matter of the Interim Independent Electoral Commission, where we stated at paragraph 47 of that judgment, and we have reproduced paragraph 47. However, the above position can be distinguished, as we have stated elsewhere in this judgment, from a matter arising in the course of a presidential election in regard to which the Supreme Court has unqualified jurisdiction and where the issue essentially relates to a petition before the court. The Supreme Court, in its advisory opinion in the gender representation matter, advisory opinion number 2 of 2012, stated that its jurisdiction to adjudicate on any dispute touching on the presidential petitions, while acknowledging the mandate of the High Court on determining the constitutionality of a statute, at paragraph 76 of advisory opinion number 2 of 2012, which again we have reproduced overleaf. The overlapping jurisdiction between the High Court and the Supreme Court only arises where interpreting or applying the provision insofar as it relates to the presidential petition. Where, however, the challenge to a statutory provision is directed as a ground in the context of a presidential petition, the Supreme Court should not find any difficulty in addressing the same in the context of a presidential petition. This does not include the power to this does not exclude the power to refer the matter to the High Court for its proper disposal depending on the circumstances of each case. We find no reason, therefore, to disturb our already settled principle of not taking away the jurisdiction of other superior courts and determining issues pending thereat. We thus would restate our position in Raila 2017 at paragraph 313, where we stated as follows: having that in mind and fortified by our observation that the interpretation of Section 14 of the Election Offences Act is a live matter at the High Court, we are unable to address our minds to any allegation that touches on this section. That is the end of the matter. Similarly, we leave the issue of the unconstitutionality or otherwise, or invalidity of Section 83 of the amended law to the determination of the High Court, where the matter is currently under consideration. In stating so, we see no prospects of the High Court making a finding that would affect our determination of the present presidential election petition. Thank you, Chief Justice.
Thank you, DCJ.